Welcome back to the 10th episode of How to Retire. I'm Scott Newhouse, and we are talking about creating or reviewing your estate plan. Before we get into it, we've got to start off with our quote. It's coming from my favorite fictional lawyer, Saul Goodman. He says, and he's saying this to Walter White in the TV show Breaking Bad, "Did you not plan for this contingency?" When Walter and Jesse were getting in some big trouble. "Did you not plan for this contingency? Well, next time plan for it, would you? The Starship Enterprise had a self-destruct button." I'm just saying. Saul Goodman, wise man, and it's very apt for estate planning. So, before we get into it, disclaimer, I'm not an estate planning attorney. I'm not licensed to practice law anywhere. I cannot give you any specific estate planning advice. We're just talking from an educational perspective. What do you need to know about your estate plan? And my honest to goodness, most sincere recommendation for this episode is go talk to an estate planning attorney in your area, in your state, who can help you out with this. So let's talk about the estate planning items that we need to think about. First of all, do you need a trust? A trust is an instrument where you can put different assets inside of it, and then you can set instructions about how and who you want to receive those assets at what time and how they're going to receive it. And so to be more specific, you typically would not put your Roth IRA or your 401k inside of a trust because that's its own account and it's got its own beneficiary designations. So we're leaving that aside. But you might, for instance, see your house or an individual or joint investment account go inside the name of the trust, and then it's going to be able to catch all of those assets that don't have necessarily a beneficiary designation attached to it. And so some people might ask, Scott, why would I need a trust versus like something like a living will, which is not a bad item to have. And it really does depend, but a trust offers you a few different things that a living will doesn't necessarily. The first is you have much more control during your life and at your passing with the instructions you're able to put in a trust versus what you can put in a will. Second of all, a trust offers more opportunity for privacy. If there's something in your estate that you don't want to get public, you typically would want to look more at a trust than a will. And then lastly, a trust, when you put all of your assets in it, it's going to avoid something called probate. Now, probate is a potentially costly and potentially time-consuming process. And so essentially, if you have assets that are not designated to go to your primary beneficiary, a contingent beneficiary, if it's not designated in your trust who's set to receive it, if it's just out there and you forgot to name beneficiaries on that asset, it's actually going to have to go through a court process for the court to figure out where it goes. Now, it's not going to just go to some random person. It's not going to go to Scott Newhouse. It's going to go to there's a list of different family members that are set to receive your assets. So mom and dad, typically it would go to the kids. If mom and dad passed away, it would typically go to the kids. Kids aren't around, maybe a sibling. Siblings not around, maybe a parent, and on and on and on. But the point is, it goes through the court and it goes through that process, which may be what you want. It may not be what you want. So that's the first thing. You do lose control by having your assets go through probate, and you can't just name someone directly. That's a big issue. Second big issue, it's a court process. Government process. Do you think that's a really timely process? It's not. It can take months. It can take years for this whole thing to settle because, frankly, you didn't name a beneficiary on these assets so that your beneficiaries, your kids, whoever, they can't receive them right away. They have to, sit through this long, arduous process. The third issue with probate is it can be costly. Now, some different states have different rules, so it's not a uniform rule across the U.S., unfortunately. But I know in some states, the probate fee is a flat fee, so it's $200, $500 to go through a probate process, and that's what you pay the government to administer probate. In other states, though, it's based on a percentage of assets that go through probate. So if you're in Southern California and you've got a nice but modest for California prices of a home worth $800,000, a percentage of that home, if it goes through probate, is going to go to the government, not to your kids, not to your charities. not to go to anyone you care about. It's going to go to the government because you did not place that house, that asset that doesn't have a beneficiary. You didn't place it in the name of a trust so that you can avoid probate. And so that's really a really big advantage of having a trust. And it's something to think about. And it's really important that if you're living in a state where they're going to charge you a percentage of your money that you've worked so hard for, they're going to charge a percentage of that, because you forgot to name a beneficiary or put it in a trust. You've got to fix that, and you've got to know that you're in one of those states where they're going to try and take as much as they can if you make a mistake, and you've got to make sure that you don't make those mistakes. And so that's another point that I had there. And then also a living will is a really great thing to consider as well, and it's going to have some similar benefits to a trust. So let's keep on going on other estate planning items that we need to think about. The first is, do you have financial and medical powers of attorney? And so these are essentially documents where you're going to be able to name other people in your life to be able to make decisions on your behalf if you are not physically or cognitively able to make those decisions. So I'm going to give you a really terrible hypothetical. I apologize in advance, but let's hypothetically say that you and your spouse are driving in a car. You get in a really terrible car accident. Neither of you are cognitively able to make decisions for yourselves, especially when you get to the hospital and you go see a doctor. You might benefit from having named other people as your medical power of attorney beyond your spouse. So your spouse might be the first person you name, but then you have a backup medical power of attorney and then a backup to the backup. And so then that person can come to the hospital and assist the doctor with whatever your wishes are to be carried out at that time, which coincidentally goes in with my next point, which is an advanced medical directive. And so an advanced medical directive is essentially when you can name what you want to happen to you in terms of your body and your health, again, if you're not cognitively able to make those decisions for yourself. So do you want, pain relief during certain periods? Do you want to be, left on that proverbial ventilator for X amount of time until you can see if you recover, and then if we can't recover, then we'll just say goodbye. You can name out so many other contingencies about what you want to happen with your body and your health if you are not able to make those decisions at that future point in time. And so that's something really important to put down in writing, sign it, notarize it, and just make sure that everyone close to you, especially your spouse, knows what your wishes are, and they can access it, obviously. And so I want to make one more point about the financial powers of attorney. Obviously, we want to have someone who's going to be able to make those medical decisions for us, but then we also have to realize that, even if our bodies are still there might be a point in time where we're not cognitively able to make really good financial decisions for ourselves. And so we might want to appoint our kids or someone else to help, pay our bills and manage our finances if we're not able to do that ourselves. There's a few more estate planning items that we need to think about. Do you have primary and contingent beneficiaries on all of your investment accounts? We've got to make sure that you have both primary and contingent. Primary is obviously if I pass away, the primary person would receive the money that I set out to give them. And then if I pass away, as well as my primary beneficiary passes away, potentially a spouse, if we both pass away at the same time, then that money would go to the contingent beneficiaries. And so that's how that works. You want to fill out both of those. You also have to ask yourself, are our kids capable of handling their inheritance? If not, it might be a good idea for us to talk to them about money, maybe take them through some kind of money course. I know, many people have varying opinions on them, but I think Dave Ramsey's Financial Peace University is a great course. The Total Money Makeover is a great book to kind of get started on understanding how to handle money in a wise way. But that's really something you got to think about, especially if you've got significant assets. I have known people in my life who have received big lump sums, either through people passing away or other events occurring, and they just wake up one day with one day they don't have a lot of money. The next day they do have a lot of money. Sometimes they don't spend it very well. And so we just want to make sure that your kids don't turn into that and they can handle it. And we got to if you've feel like they can't. We got to think through and plan through, okay, how are we going to get the kids up to speed? Also, are there any charitable goals that you want to make during your lifetime and at your passing? If no, that's fine. If yes, you really should think about doing it during your lifetime, as long as the numbers make sense and you're not going to run out of money. And then obviously, we want to make sure that if you are interested in making a charitable donation at your passing, that it's listed as a beneficiary either on your investment accounts, listed in your trust, and then you set the dollar amount or the percentage that you want to go there. Also, we've got to remember that, life is going to change. I've worked with a number of people who set up their trust in the 1990s and in the 2000s, and we look at the trust that they created back then, and we get a little bit of a chuckle because so many of these names of the people that were listed in these trusts as the medical powers of attorney, as the beneficiaries, they're not with us anymore, and that's just life, unfortunately. So, I set a parameter of reviewing this every 2 years. You could do it every year. Maybe you could do it every 3 years. I'm not too worked up on 1, 2, 3. I'm more concerned with, hey, are we reviewing this to make sure that, are the people listed in our documents, in our estate plan, are they still alive? Are we still friends with them? Those sorts of questions. And if they're not, we got to update the documents. Now, there are some estate planning things that we absolutely have to avoid. Probate. I just don't think anyone should ever go through this process. Government makes some money. It's more hassle for your kids or your beneficiaries, and it's gonna be a extra added fee that we didn't have to pay if we had planned ahead. So let's plan ahead. As Saul Goodman reminds us, we need to plan ahead. We need to remember that. Money is obviously an emotional topic for a lot of people and a lot of families. And so we want to be mindful of any potential issues with your kids or your beneficiaries receiving whatever they're set to receive. And so that's a personal question. Hopefully everything is hunky-dory in your family and no one's going to be offended or get in any kind of fights. But if you think there might be something like that, that's where, preventative action can really come in place and be something for us to think about there. Also, a lot of people might have an idea of, I want to be laid to rest in this location. I want to be cremated. We just got to make sure we put it in writing. And we got to make sure we put it in writing, communicate with our spouse, kids, whatever. And that, wherever we put it down in writing, they have access to it. So just in case they forget, they have an easy way to pick it back up and follow your final wishes. The last thing that we should avoid is DIY estate planning. I know a lot of people, that might listen to my podcast or listen to my YouTube videos. They like to DIY their finances. That's fine. I'm not trying to convince them of anything, not in the slightest. I really don't think, though, you should DIY your estate plan. Creating your own trust, will, thinking through your powers of attorney for medical and healthcare decisions, thinking through your advanced healthcare directives, thinking through when you want your kids to receive money at certain stages of their life. There's so many different issues that could go wrong. One mistake and your kids, your beneficiaries are going to have massive headaches. So I just don't think it's worth it to try and do all of this on your own. I would definitely go seek out a professional estate planning attorney who can help you put all of this together. Now let's go to our estate planning recap. The first thing that we're going to recap is a trust versus a will. A trust has different elements that a will does not have. It has more control, more privacy, and it helps you avoid probate. But I know some people, they speak with their estate planning attorney. Their estate planning attorney says, I don't think you really need a trust. I think a will, when we structure things a certain way, is going to be sufficient for you. And that's coming from estate planning attorneys. But I've also known estate planning attorneys who say, no, I really think you need a trust. So go speak to an estate planning attorney in your city who can help you make that determination. Another thing that we must have, is we have to have health and medical directives as well as financial directives. I think that's a non-negotiable. We got to put that in writing. We have to get that in place. Another thing that we need to do is we need to be intentional about your legacy and your charitable goals. Who do you want to give money to at what points, and what's going to be fulfilling to you in terms of kind of the impact that you can make with your money. And then my last point for our recap is we have to review and update our beneficiaries as well as our other agents on a regular basis. Life is going to change. The people in our lives are going to change. And we've got to make sure that, as some people pass away, we have new updated beneficiaries, powers of attorney, etc., so that, we're covered in case and when something happens to us. So that is all I have with this estate planning video. I hope you enjoyed it, and I will see you in the next one.